Good evening. On behalf of the Federalist Society Student Division and the Charleston School of Law Federalist Society, we welcome you to tonight's Feddie Night Fights, Monday Night Law edition with Professor Kurt Lash and Anthony Sanders. My name is Alexandra Toney, and I am the president of the Federalist Society chapter at Charleston School of Law. And it is my honor to introduce our referee for tonight, Jonathan Urick. Urick is Associate Chief Counsel at the U.S. Chamber Litigation Center, the litigation arm of the U.S. Chamber of Commerce. Urick rejoined the chamber after helping launch the national litigation boutique, Lahotsky Keller, where he represented large corporations and trade associations as one of the firm's early partners. He previously served as senior counsel for the Chamber Litigation Center, primarily covering arbitration and class action issues. Before his stint at the chamber, Urick practiced law at McGuire Woods, one of the firms on the firm's appeals and issues team. With a diverse litigation and commercial practice focused on appeals and motions, Urick represented a variety of businesses across federal and state courts. Urick served as law clerk at all three levels of the federal judiciary, including Justice Scalia and Justice Thomas of the U.S. Supreme Court. Urick graduated Order of the Croix from the University of Virginia School of Law, where he served as Articles Development Editor of the Virginia Law Review. He received his undergraduate degree in economics from the University of Delaware. And with that, I will hand it over to our distinguished referee.
Thank you, Alexandra, and thank you to the Federalist Society and the Charleston School of Law chapter for hosting this wonderful debate. And thank you especially to the Federalist Society's graphics department for that very accurate depiction of my muscles and my waistline. I can assure you, even though I'm not wearing my tight-fitting referee shirt this evening, that is a very accurate depiction of my physique, and I think the same is probably true for the depictions of our two debaters tonight. And we have two wonderful debaters indeed tonight on Monday Night Law. So in one corner, we have Anthony the Sandman Sanders, the director of the Center for Judicial Engagement at the Institute for Justice and a senior attorney there. Anthony joined IJ in 2010, and as the director of the Center for Judicial Engagement, he educates the public about the proper role of judges in enforcing constitutional limits on the size and scope of government. And as a senior attorney at IJ, he litigates cutting-edge constitutional cases protecting economic liberty, private property, free speech, and other individual liberties in both federal and state courts across the country. And one of Anthony's particular areas of expertise is on using state constitutions to protect individual rights. And to that end, he's the author of the forthcoming book that is the subject of tonight's debate, which is called Baby Ninth Amendments: How Americans Embraced Unenumerated Rights and Why It Matters. And the book comes out in early May. Anthony has also written several law review articles on state constitutional law, unenumerated rights, judicial review, economic liberty, property rights, and much more. And before joining IJ, Anthony clerked for a justice on the Montana Supreme Court, and he worked for several years in private practice in Chicago. Now, opposing Anthony in the other corner, we have Professor Kurt the Whip Lash, the E. Claiborne Robbins Distinguished Professor of Law at the University of Richmond, where he teaches and writes about constitutional law. Professor Lash is a truly prolific constitutional scholar and historian, to say the least. For starters, he is one of the nation's foremost scholars of the Reconstruction Amendments, particularly the 14th Amendment. He's already published one book on the 14th Amendment, plus a 2-volume collection of original documents relating to the framing and ratification of all 3 Reconstruction Amendments. He's currently working on another book about the enactment of those amendments. But most relevant for our debate tonight, Professor Lash is also a leading scholar of the Ninth Amendment and its original meaning. He's written several law review articles on the Ninth Amendment, plus an entire book on the subject called The Lost History of the Ninth Amendment. So prolific indeed. Before I turn this over to our debaters, though, I just want to set the stage, the legal stage, a little bit. So to date, most of the constitutional debate over unenumerated rights has focused on the Ninth Amendment to the U.S. Constitution, that is the federal Constitution. And that amendment is only 21 words long, and it reads this: the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, conservative and libertarian legal scholars and Federalist Society members have vigorously debated what those 21 words mean in the federal Constitution. And FedSoc has hosted some of those very debates, often featuring Professor Lash and Professor Randy Barnett, another leading originalist scholar of the Ninth Amendment. But tonight's debate is primarily not about the Ninth Amendment, at least not directly, although I'm sure our debaters may have something to say about the Ninth Amendment. Tonight's debate is instead about the meaning of the 33 so-called baby Ninth Amendments in state constitutions with similar language modeled on the federal Ninth Amendment. And that's right, believe it or not, 2/3 of all state constitutions have some type of baby Ninth Amendment addressing unenumerated rights. And we are currently amid a long overdue renaissance of renewed interest in state constitutions, led perhaps most prominently by my former boss, Judge Jeffrey Sutton of the U.S. Court of Appeals for the Sixth Circuit. And like Judge Sutton, Anthony has proudly taken up the mantle of state constitutionalism. And as Judge Sutton and now Anthony have reminded us, in constitutional litigation, we usually have two shots, not just one. We have the U.S. Constitution, with which we're all very familiar, but we also have state constitutions that all too often get overlooked. Perhaps if a constitutional argument for an unenumerated right doesn't work under the U.S. Constitution, we may still have one more shot to vindicate that unenumerated right under the relevant state constitution's baby Ninth Amendment. And Anthony is here to tell us that we do have another shot, or at least we should, in the 33 states with baby ninths, despite stiff judicial resistance to enforcing unenumerated rights. As Anthony lays out in his book, and he'll elaborate tonight, in his view, the baby ninths provide robust judicially enforceable protection for certain unenumerated rights, and the traditional arguments against this individual rights reading of the Ninth Amendment don't transfer to the baby ninths, but I'll let him elaborate all that. And I'm sure Professor Lash will have plenty to say and perhaps much to disagree with about that thesis. And if I'm understanding Professor Lash's scholarship correctly, and please, Professor, correct me if I'm wrong, in his view, the federal Ninth Amendment protects unenumerated individual and collective democratic rights primarily by requiring a narrow construction of federal enumerated powers. And I wonder if Professor Lash takes a similar view of the state baby ninths, and I look forward to his take on Anthony's fascinating new book and what the baby ninths may teach us about other areas of constitutional law. So let's get this debate underway. Are you both ready to rumble? So just so the audience knows, here's how the format is going to work. So in the first round, I'll start with Anthony, and I'll let each debater talk for about 10 to 15 minutes. I may occasionally interject with questions, or perhaps I'll leave my questions for after each debater's remarks conclude, and I might ask one or 2 points. Then after the first round, we'll do another round of about 10 minutes for each debater, and then we'll open the program up to questions from the audience. And please use the Q&A function in Zoom to submit your questions. So with that, all right, gentlemen, I want a good, clean fight. And in the words of former TV judge, real judge, and boxing referee Mills Lane, let's get it on. Anthony, take it away.
It's on. Or, as I usually say, hello, good evening, and welcome. And thank you to Jonathan for that lovely introduction. And thank you to Alexandria as well, and the Federalist Society and the student chapter of the Charleston School of Law, their lovely city of Charleston, where I had the pleasure of visiting recently. And especially, I'd like to thank Professor Lash for agreeing to this cage match tonight. He is an erudite scholar and of much greater renown than I am, so I should feel lucky just to be in this cage, even if it, maybe isn't the nicest place for a Monday evening. But we'll see about that. Now, I am not as steeped in wrestling lore, actually, as I believe Jonathan is. I don't know about Professor Lash's background, but I followed wrestling roughly from about 1986 to 1989. So that's kind of my cultural knowledge. Now, some of my references, therefore, might be lost on some of our younger viewers, our law student participants tonight. But one name that you probably do know from that era is Hulk Hogan, the Hulkster. In that time period, everyone loved the Hulkster, right? He was the guy you rooted for. Later, I think he kind of turned a little bad. But at that time, when I was in elementary school, junior high, following wrestling, He was the guy you rooted for when he would fight those despicable wrestlers managed by Bobby the Brain Heenan. And when he came into the ring, he would have this song that I'm sure many of you probably know if you heard it. Don't worry, I won't sing it. But it was the song Real American by Rick Derringer. And the refrain was, I am a real American. Fight for the rights of every man. I am a real American. And fight for what's right. Fight for your life. Now note in there what Hulk's trying to get across. He says, fight for the rights of every man. And I'm sure Hulk would include women as well. What does he mean by that? Fight for the rights of every man. Sounds pretty broad, right? Well, I don't think what he's getting at is fight for the specifically enumerated rights in the first 8 amendments of the U.S. Constitution and a few other rights that are otherwise mentioned in the Constitution, and then those that are specifically enumerated in your own state constitution. He's not getting at that. He's just getting at rights. He's getting at freedom. What Hulk's talking about there is freedom. That's what he's fighting for. So that same spirit that is what's going on in that song is a similar spirit that Americans exemplify when they craft their own constitutions. Now, we all know about the US Constitution, but as Jonathan was just talking about, we have state constitutions as well. In fact, in our history, Americans have adopted a new state constitution about 200 times. So we adopt constitutions a lot. And when we do that, we channel some of this spirit of what Hulk was talking about in broadly protecting rights. Now, I'll get to that in a minute. We'll talk a little bit about the history. There won't be too much time tonight for much of that history. You can read the book in the future if you like. But what I want to talk about right now is push constitutional law in general to the side and just think about what you did yesterday. Or yesterday was Sunday, so maybe what you did last week. So what do you do? Well, you got up at a time you thought was best for you. Maybe you wanted to sleep in a little more, but you got up because you had whatever you had going on that day for you and those around you. You made a choice of what to eat for breakfast, for lunch, for whatever. And you made that choice because you wanted that for you. Maybe you could have had something a little more healthy, but you made that choice for yourself, not because some outside authority chose it for you. You also did other things, like if you're a parent, you might have taken your child to school, and it might have been a school you chose for your child over other options. You, maybe not so many of the law students, but others might have gone to work, and that was a job that you might have chosen over other options that you had. Or it might have been a path in life that you took that led to that job, and you chose that path over other paths you could take. There are other, probably more mundane things you did with that day, but that were important to you. You might have tended to your garden in your front yard. You might have got together with friends and played a game. You might have played basketball or poker or something like that. You might have fixed up your house in some way, or you might have done something as simple as put together your stamp collection. So all of these were choices that you made for yourself and for those around you. You thought they were best. But what if your state legislature passed a law that restricted what you could do in these various ways? And say it was a law that you thought wasn't all that related to public health or safety. It just seemed arbitrary. Well, you wouldn't be very happy about that. And say you're not a law student or a lawyer, you're just an average American. You would think, this law is ridiculous. You know what? This law violates my rights. I need to do something about this. And being an American, you would know there's this thing called a constitution, and it protects your rights. So you go to the Constitution and you look, and you see a bunch of rights. You see speech, religion, search and seizure, cruel and unusual punishment. But notice that the examples that I gave a little earlier, none of them are really in the Bill of Rights, in the US Constitution specifically. And so, okay, well, nothing there. And maybe you're savvy enough to know that you have a state constitution, and that has a Bill of Rights. And you look down that, And you also don't see those rights. You might see some other rights that are in your state constitution that aren't in the US Constitution, but not the specific right you're looking for. And you think, what were they thinking? They should have spent a little more time listing out all these important rights, because now I can't exercise this freedom that I want to exercise. But then you see at the end of the US Constitution, and also if you're in those 33 states that Jonathan mentioned, you see this very similar language in your own state constitution. And it's the Ninth Amendment, the language that Jonathan read out earlier. Now, what I argue in my book is what that language does is it refers to more rights beyond just those written in the Bill of Rights. And by the way, I should say, I disagree with Professor Lash on what that means in the Ninth Amendment. But perhaps you agree with him. And perhaps you agree with him about the rest of the US Constitution. It just doesn't protect unenumerated rights. I will be happy tonight if at the end of the debate, I convince you that maybe that still isn't true for the US Constitution, but it is true for your state constitution. And so you can think that there's no unenumerated rights in the US Constitution, which again, I don't believe, but maybe you do, but nevertheless, that there are in your state constitution. Now let's take another angle on it. Instead of the example of an average American who can't exercise a freedom, I'm going to put you in a very different situation. Your state is having a new constitutional convention, and you are a delegate to that convention. And again, Americans have done this many, many times. And you go to the state constitutional convention, and you are put in charge of the Bill of Rights Committee. Pretty cool. So you are the chair of this committee that is going to draft a Bill of Rights that's going to send it on to the convention and then on to the voters. But you are very solicitous of your fellow delegates in the committee. And you say, okay, we want a really rights protective Bill of Rights. I want you guys to give me ideas. And so you take the former Constitution's Bill of Rights, which has a lot of the rights that you've heard of before. Most states do. Speech, press, religion, all that stuff. Cruel and unusual punishment. And then maybe you get a few more in there that are from other state constitutions. One that's often popular is no imprisonment for debt. Okay, we'll put that in there. And then you get more and more suggestions. And maybe there are suggestions such as the ones I talked about earlier. Right to choose a school for your child. Right to gardening your front yard. And you might think, gardening your front yard, why would you put that in there? Well, we at the Institute for Justice actually represented a couple of years ago who were cited by their city for planting vegetables in their front yard. Fruit was okay, not vegetables. And so you keep getting suggestions, and eventually you realize it hits you that there are an infinite number of rights. Why is that? Because there's an infinite number of ways that you can exercise your liberty or that you can use your property. But you can't put them all in a constitution. Even if you put loads and loads of rights, right? Not literally infinite, but a whole bunch, you would have something that my generation and older used to call a phone book. And you can't have a constitution for a phone book. I mean, this is America, not Brazil or Alabama. They have a pretty long constitution too. It's not rights though. So you say, what are we going to do here? And then you come to a conclusion that you can list a bunch of rights and then you can imply other rights. And what you settle on is essentially the language of the Ninth Amendment, because it refers to certain rights. It refers to the rights that are enumerated. And then it says there's others retained by the people, and those are protected as well. Now, not only is there the language of the Ninth Amendment that is in these 33 different states, other state constitutions and some of those same constitutions also will use broad language to protect whatever they protect, I think, unenumerated rights. For example, a lot of states have these things that Stephen Calabresi has written about called Lockean natural rights guarantees. They'll say things like the right to pursue happiness, right? That sounds familiar. That's actually in those constitutions, or just the right to liberty or to acquire property. those are pretty close to unenumerated rights clauses. And so by looking at all these state constitutions, you see that they're designed to protect some rights and then the infinite number of other liberties that we can exercise. Now, I know one attack on this is going to be, look, you say that, and then you give that power to judges to interpret. Judges are going to come up with all kinds of crazy rights, like, a right to be provided health care, or a right for everybody to have a pony, which is an example I give in my book. Now, you could have a provision like that in a state constitution. It's not insane to think that someone would draw that up. Luckily, when Americans have put our constitutions together, we don't have provisions like that by and large. We do have some positive rights, but we don't have broad, open-ended language. Instead, we've been pretty savvy, I think, when we've written our constitutions. When we do have unenumerated rights clauses, we have them refer to our natural liberties, our retained rights that we have, that when we enter into society, we give up some of them, but we retain most of them. And that's what the language of the Ninth Amendment and these baby Ninth Amendments are referring to. And so at the end of the day, when we look at all these state constitutions, we can see that we could go into state court and have them enforced to protect our liberties. Now, that's the primary argument I make in the book, is that state judges should take these more seriously, and we should take them more seriously when we're using them to protect our rights against state and local government, which, if you haven't heard, does most of the governing in this country, despite everything we always hear about the federal government. Now, I know that Professor Lash is going to focus a little bit more on the US Constitution itself. And so I will have a parting shot here that maybe is going to be a little more disagreeable to him. And that's that, what do we take away from all these state constitutions doing what I claim they do? Well, we see that unenumerated rights are not some kind of weird outlier in law that, maybe the Lochner Court and the Warren Court made up, and otherwise it's not really part of our heritage. Actually, unenumerated rights are normal. In fact, they're popular. And if they're that normal and popular, then when the US Constitution was put together, whether originally or as amended, it's not that weird to think it protects unenumerated rights. That doesn't mean we interpret it that way from that argument, but it does mean we should be open to it because it's a normal thing that Americans do. Thank you.
Thanks, Anthony. That was really outstanding. So your book is super fascinating. And just before we turn it over to Professor Lash, could you just very briefly describe, the main arguments against the individual rights interpretation of the federal Ninth Amendment? You don't have to, I know you list like 6 different very nuanced theories in the book. You don't have to go through all 6 of those, but the high level arguments against the individual rights reading of the Ninth Amendment, and why those arguments don't work in your view for the baby Ninth Amendments.
Sure. So what Jonathan's referring to is as a way of kind of getting at what the state constitutional language might mean. Let's look at what the Ninth Amendment has been argued about meaning. And I focus on originalist meanings because that's where I'm coming from, and interpreting constitutional texts is as a type of originalist. But I don't think it has to be just originalist theories. But essentially, there are a number of them. Some, you're right, some are nuanced, some only a couple maybe scholars have come up with. But there's the major ones, I think, are the individual rights theory, and that's the one that Randy Barnett and others have written about for many years. There's the Federalist model that I'm going to butcher, but Professor Lash has written about, and essentially it's what you said earlier, Jonathan, that reading enumerated powers of the federal government narrowly. And then there's a couple others. One, Professor Michael McConnell has an interesting reading of the Ninth Amendment, that it is a way to read statutes to not infringe on these retained rights unless they're very explicit about doing so. And then there are some non-originalist readings of the Ninth Amendment that the Larry Tribe, I don't know if he still believes this, but when he wrote about it many years ago, he said that it's not that the Ninth Amendment itself has rights, but it kind of reminds us that we should be very open to other provisions in the Constitution having unenumerated rights protections. Now, when you get to the state constitutions, I just think a lot of these theories don't work, especially say the Federalist model or the other models, because when you have a state, you're not talking about federalism anymore. And it could be, and I think this is, maybe a way to bridge the gap of someone who believes what Professor Lash believes for the Ninth Amendment, but doesn't know what to make of a state constitution. It could mean it meant one thing at one time, and then a number of years later, when they're putting together a state constitution and they go on the shelf and they take this language and they put it in their own constitution, it could mean something a little bit different because of the context and the passage of time and all that. So I give that, it's not very good for a cage match, but I give that as a bit of an olive branch for someone who wants to try to put all this together, but maybe has some reservations.
Great. That's really helpful. And so last question, and then I promise I'll turn it over to Professor Lash for his response. So briefly, what in your view is the core of what these baby knights protect, right? The substance of what they protect. Is it any right you can dream up? Is it Lockean natural rights? Is it Lockean natural rights plus some other stuff? Like, could you just say a few words on that?
Yeah, it's and I have a long argument in the book. Hopefully won't be use some sand and put people to sleep as the Sandman, but you can explore this in the book. And it is that they are Lockean natural rights. And why is that? It's because they use the word retained. And I explore this. I use some hypotheticals to try to push on it. At the end of the day, I think when you read the language of the Ninth Amendment, whether it's the Ninth Amendment or these baby knights, retained has this social contract meaning. You can think the social contract is complete balderdash, and it's just a legal fiction that's been, was written about by 18th century, 17th century philosophers. And I believe it actually was not really a real thing, but it's a way of thinking about how we organize society, and it's embedded in our constitutions. I mean, state constitutions, apart from just these baby knights, will have all this language that assumes a social contract, a kind of Lockean understanding of rights. And so that's what it is. It's not your right to something positive. It's also not your right to say certain criminal procedural protections. You could do that with other language, but you don't do it with this language. But what it's getting at is this really raw, maybe you could even say Hulk Hogan type of feeling of just your freedom. It protects your freedom. Government can still do stuff, but it needs a reason to do it. It can't just do whatever it wants and wave the rational basis wand and get away with it.
Great, thanks. We might later get into how we operationalize all this, but I want to turn it over to Professor Lash for his response.
Well, thank you. Thank you, Jonathan. I appreciate you moderating this crazy cage match. I want to thank Alexandra and the Charleston Law School Federalist Society for hosting the general event. And I'm especially glad to be here discussing the Ninth Amendment with my friend Anthony Sanders. I want to say a few words for the book that's coming out. Anthony's written an incredible book, and it's about a subject that a lot of us have been wondering about for a long time, these so-called baby Ninth Amendments. There was some early scholarship a few decades ago that mentioned their existence, but Anthony's the first person who has really dug into the historical origins of these state constitutional provisions and talked about their possible use in contemporary law. So he's really the first person to do that. And Jonathan, as you mentioned, it's a perfect time for the book. People are taking state constitutions far more seriously now than they have in the past. And so it's quite a timely moment to be bringing to people's attention ideas about state constitutions and the role that they might have in our broader understanding of American liberty. So go out and buy the book when it comes out in May and read it and I've had a chance to look over a manuscript of the book. And what you'll find that I think is important for tonight's debate, what you'll find when you read this book on the baby Ninth Amendments, you're not only going to learn about baby Ninth Amendments, you're also going to learn about baby 10th Amendments. As Anthony shows us in his book, it's impossible to study these state constitutional Ninth Amendments without also, at the same time, studying really the counterpart, the state counterpart for 10th Amendments, because many times these baby Ninth and baby 10th Amendments were adopted at the same time and placed in the same clause in the Constitution. And so I want to give you just one quick example because I think it's important to the general debate. I'm about to quote to you Section 20 of the 1851 Ohio Constitution's Bill of Rights. And this is a provision that Anthony talks about in his book, and he finds it to be representative of baby Ninth Amendments. Okay, so here it goes. Here's section 20. This enumeration of rights shall not be construed to impair or deny others retained by the people, and all powers not herein delegated remain with the people. And as Anthony notes in his book, this section 20 of the Ohio Constitution is really quite common in terms it's repeated not in every state constitution, but in many, this combination of Ninth and 10th Amendments that are placed in the exact same position. The Ohio framers in 1851 apparently thought that these two ideas, these paraphrases of the federal Ninth and 10th Amendments, were so closely aligned that they could be part of the same mutually reinforcing provision having to do somehow with the people's retained powers and rights. And I think this is interesting because when you compare that combination of the Ninth and 10th Amendments with how we think about the Ninth and 10th Amendments today, you'll find something very different. When it comes to the Ninth Amendment in the federal Constitution today, it's usually described as protecting individual natural rights, rights that can be appropriately invoked against states, as the court did when it cited the Ninth Amendment in Griswold against Connecticut, striking down a state law in that case. The 10th Amendment, on the other hand, is generally viewed today as representing a completely different principle, one involving state rights and state autonomy. And that, of course, is the opposite principle from the Ninth Amendment one cited by the court in Griswold. So today we view these two amendments as representing different principles which are often in conflict. But for some reason, the people in 1851 in Ohio didn't think there was any conflict at all. They thought the principles were mutually reinforcing, and I think they were absolutely right. In fact, I think that Section 20 of the 1851 Ohio Constitution contains a really important clue to understanding not just state-level baby Ninth and 10th Amendments. I think this particular provision is an important clue to understanding the original federal Ninth and 10th Amendments as well. And so for the few minutes left to me, I'm going to try to explain this connection. But in doing so, I've got to go back to the beginning. I've got to go back a couple of 100 years and talk about the foundation of the country and the rise of American federalism. So let's start with something Lockean. Okay, let's start with the Declaration of Independence. According to the Declaration, governments, quote, derive their just powers from the consent of the governed, and it is the right of the people to alter or abolish their government and to institute new governments in whatever manner, quote, seems most likely to affect their safety and happiness. Okay, end quote. Now that language in the Declaration expresses the basic principle of American popular sovereignty. Government by consent of the people. And the people as sovereign retain the right to alter or abolish their forms of government. And the colonies, of course, did so successfully in the American Revolution. And following that war, these colonies were now free and independent states, again, to use the language of the Declaration, each with their own governments established by the consent of the people in those states. Now, under the Articles of Confederation, these free and independent states coordinated their activities for the purposes of fighting the Revolutionary War. But as the Articles of Confederation made clear, although the states coordinated for some purposes, quote, each state retains to use that word, and let me repeat that, each state retains its sovereignty, freedom and independence, and every power, jurisdiction, and right, which is not by this confederation expressly delegated to the United States. So you have another principle of popular sovereignty that existed at the time of the Revolution for each of the states. That sovereignty is retained under the Articles of Confederation. And when those people went about drafting their own state-level constitutions, they generally delegated general legislative authority to their state assemblies to do whatever was good for the health, welfare, and morals of the local community. And it was because the people in the state delegated this general legislative power to their assemblies that most states found it appropriate to also add a Declaration of Rights that enumerated certain restrictions on the general authority that they had delegated to their state constitutions. So that was the scheme at the time of the adoption of the federal Constitution, about 13 years after the Revolution. And when it came time to draft that federal Constitution, the drafters decided to adopt a completely different kind of constitution than what had operated in the states. Rather than delegating general authority and adding a Bill of Rights, they created a national government of limited authority, limited enumerated powers. And under such a government, there was no need for a Bill of Rights. In fact, adding a Bill of Rights might be construed to imply the creation of a federal government of general power like you had in the states. So you shouldn't add a Bill of Rights because it would raise that erroneous implication, or at least that was the Federalist excuse for not adding a Bill of Rights to the original Constitution. Now, we know that several states insisted that adding a Bill of Rights should be added anyway, if only for greater caution. So Madison and the Federalists agreed to do so, and true to their word, in the first Congress, they proposed a list of amendments that ultimately became our Bill of Rights. But Madison, in offering this list or Declaration of Rights, in order to prevent that addition from being construed as altering the basic nature of limited enumerated power, he proposed the addition of what we now call the Ninth Amendment. And again, just to quote that amendment, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now notice, the Ninth Amendment does not talk about the enumeration of certain individual natural rights. It doesn't talk about certain individual Lockean rights. It talks about other rights in general. Limiting it to natural rights would have been far too narrow for the people in the states. Those people insisted on retaining all powers and jurisdictions and rights not otherwise delegated into the hands of the federal government. And that went way beyond natural rights. It included the collective democratic right to vote on matters relating to property, to zoning, to contract, to tort, criminal procedure, and in the beginning to slavery. And to put it mildly, all of these retained powers and rights were not all matters having to do with the individual natural rights. They were, however, all subjects retained by the people in the states as a matter of right. Now, look at what they then put immediately after the Ninth Amendment. The 10th Amendment, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Like the Ninth Amendment, the 10th expresses a principle of popular sovereignty. The people of each state retain the right to delegate their reserved powers through their local government or to retain them to themselves and place them beyond the reach of even their local state governments. So the 10th Amendment should not really be viewed as a states' rights amendment. It should be viewed as a people in the states' rights amendment. And together, the 9th and 10th, therefore, were meant to work in tandem to limit the powers of the federal government and preserve the retained rights and powers of the people in the states. And that's why courts and commentators for the first century and a half of our American history cited the 9th and 10th Amendments at the same time as working together, with both amendments helping to preserve the people's retained right to local self-government. This is how James Madison described the 9th and 10th Amendments in 1791. This is how St. George Tucker described the 9th and 10th Amendments in the first constitutional treatise in 1803. And again, it's how every court and commentator talked about it up until the time of the New Deal. So that close connection of the 9th and 10th Amendments from the very beginning explains why states, when they began to construct their own constitutions as the decades went forward, were so comfortable in adding the same dual principles of popular sovereignty into their state constitutions. So again, listen to Ohio's 1851 Section 20. Quote, "This enumeration of rights shall not be construed to impair or deny others retained by the people, and all powers not herein delegated remain with the people." This provision simply transfers a statement about popular sovereignty from the federal level to the state level. The state level 9th and 10th Amendments establish the same principle as their federal counterparts. Neither the federal nor the state governments can abrogate the retained rights and powers of the people. Okay, in conclusion, just so we can get the debate going. Neither the federal nor the state baby ninths are about unenumerated natural individual rights, Lockean or otherwise. They're about popular sovereignty in a unique federalist system of dual governments. The people retain the sovereign right to determine the scope of delegated state authority for themselves. This means that state courts should not rely on baby ninths to add additional unenumerated restrictions to the powers on state governments, other than those demanded by the people themselves, the people of the state. If the people have chosen a system of general state power and enumerated restrictions on that power, then that state system is itself one of the retained rights and reserved powers of the people of that state. Or to put it another way, the enumeration of certain rights in a state constitution should not be construed to deny others retained by the people, including the people's retained right to decide the scope of powers delegated to their own state government. That's it for my opening statement. Now we can rumble.
Thanks, Professor Lash. Just one quick follow-up question, and then I'll flip it back to Anthony. So,
Sure.
if that reading is correct, does that render the sort of ordinary, state constitutional delegation of power to like state legislatures and stuff like superfluous? In other words, the state constitution itself already delegates these sovereign, collective democratic rights to state governments. If that's all the baby ninths and baby tenths as a pair are doing is just reaffirming that, then what additional work or safeguard do they provide?
Okay, sure. State constitutions don't delegate anything. The people of the state delegate authorities, and their delegation is written into a document called a state constitution. So if the people want to delegate general legislative power to their government, they're free to do so, and to adopt a system of general unenumerated power along with specific restrictions of power in their state declaration of rights. What they get when they add their own baby ninth and baby 10th amendments is to remind their state government that they are not sovereign, that they do not have control of the constitutional structure or the enumeration of rights, that all those things come from the voice of the people themselves. And that would be an instruction not just to the state legislature, that would be an instruction to the state courts, that whatever mixing or altering or changing of this delegation of authority and enumerated rights in the state constitution has to come from the voice of the people themselves and not from the state court.
Thanks, Professor Lash. That's great. All right, let's get this rumble going further in round two. Anthony, take it away. What's your rebuttal or reply, I should say? Oh, you're muted. Anthony, you're muted.
My apologies.
There it is.
So given that Professor Lash has focused on these baby 10th amendments, I think I will start there, and we'll go from that to what they have to do or how they relate to the argument I have in the book about unenumerated rights being enforceable. What he said about the 9th Amendment, he is much more schooled in some of that history than I am. I have my own opinions about it, but I think I will move from that to how this language is used in state constitutions, because I think it's important he said this was important too, but I think it's very important to remember that in state constitutions, in states, it doesn't have to be this way, but it generally has been that we don't have enumerated powers. We have just general powers. You might call them unenumerated powers, but usually how they're referred to is just general powers. So your state has power to do whatever, power that's delegated from the people to the government, but the way they delegate that isn't through the careful delegation that was done in 1787 for the US Constitution. It's done in a more just organic way that, well, we have a state government, us people give up power to the state government. We don't give up all our power. We're Lockean, not Hobbesian, as in Thomas Hobbes. We don't give it all up to a Leviathan. We keep something. And so how do we figure that out? How do we put that on paper is what these is what state constitutions are getting at. So a little bit of history here that I didn't pack into the first bit. The first baby Ninth Amendment, true baby Ninth Amendments, were in Alabama and Maine, and they were in 1819, which is a full 30 years after the Ninth Amendment and 10th Amendment were themselves drafted. And then slowly over the course of US history, they were put in more and more constitutions. Now, you could tell this tale for lots of different constitutional rights, I'm sure. You could write a book about, baby Fourth Amendments, and indeed people have spent a lot of time on that particular kind of provision or other provision. But over time, they've been used in more and more state constitutions. There were about a dozen of them at the time of the Civil War. They became more popular in Reconstruction. And then over the course of the 20th century, and today, as Jonathan said at the beginning, we have 33 of them. So what explains this kind of slow growth of them and how they were appended to these things called baby 10th Amendments? Now, Professor Lash talked about the baby 10th and baby 9th of Ohio in 1851. Ohio's is, to tell you the truth, a little perplexing because the way it sounds is like Ohio has enumerated powers. But the way the Ohio government has always conducted itself, and indeed all states have always conducted themselves, is that they don't have enumerated powers, they have general powers. And that's the way to think about how states exercise their powers. Now, there was a view in the 19th century that actually states were kind of more like the federal government, like the federal government used to be, with enumerated powers and very narrow powers on what they could do. But I think the practicalities of governing just won out that we think of them as enumerated power, as unenumerated powers. Now, let me give you an example. Predecessors were used in other constitutions, but I think it's a good example, and that's the Arkansas. It's actually still in the Arkansas Constitution today. So first, it has the language of the Ninth Amendment, essentially. The enumeration of rights should not be construed to deny or disparage others retained by the people, right? Now, Professor Lash is saying those rights are not individual rights. They're not like the rights that were listed right before it in that same Bill of Rights. They're this kind of right to govern yourself. Okay, then it goes on. And to guard against any encroachments on the rights herein retained or any transgression of any of the higher powers herein delegated, we declare that everything in this article, that is the Declaration of Rights, the Bill of Rights, is accepted out of the general powers of the government and shall forever remain inviolate. That's a lot of words there, but I'll give you a couple that are the most important. It talks about higher powers that are delegated and general powers and transgressions of those powers. What's going on there? That language recognizes that the state has general powers. So we're not talking about Article 1, Section 8. We're talking about general powers of government. But it also recognizes that's a dangerous thing to do. You're giving the keys to the legislature and the governor to do all kinds of stuff. And you want to have a short leash on what those keys are. And you say that there can be encroachments on the rights herein retained. Well, what is that? What are those encroachments? You're also referring to the general powers of government, which, as Jonathan just said in his perceptive question, are the general powers of the legislature to pass all kinds of laws and then have the governor go and enforce them. So what the balance that's going on there is you have rights that are retained by the people, in addition to those that were just above it in the same Bill of Rights, and then a recognition that the powers that you otherwise are giving to the government are dangerous. And you need to try to have a balance between the two. And the way that you have a balance is you accept them out of the general powers of government, and that includes those other rights retained by the people. Now, Professor Lash talked about that this is a right the rights that are going on here are the rights to govern ourselves. And indeed, over the course of history, we probably won't get up much in tonight over how these provisions have been interpreted in state courts. But over the course of history, a handful of times, state courts have kind of taken this, what I call a collective rights view of these baby Ninth Amendments. I just don't think that makes any sense. I think it is logically inconsistent. That's because you're saying that the rights to govern yourself are protected, not individual rights to govern yourselves. And yet, at the same time, you have all these powers that you've just given to yourself. I don't think it works at the state level. Now, there have been a few inventive courts that have said, well, really what's going on here is it's the right to govern yourself at the local level. So your city, there's one case, for example, that a city passed an amendment, and there was a state law that said you needed 60% of the voters, and only like 51% or something voted on it. And the state said that's unconstitutional under this baby Ninth Amendment because the right to govern yourself just requires a simple majority. And so the state statute is unconstitutional. Inventive, but there's nothing sovereign about a city. A city is just a unit of the state. Maybe if you're talking in some other context, it might make some kind of sense. So I just don't get that reading of the Ninth Amendment. I understand Professor Lash's view for the Ninth and 10th Amendments themselves, and then how they might look similar here in the States, but that's not what's going on. The other piece of example I'll give is that when state delegates have talked about these things. Now, again, I think he and I kind of have the same originalist interpretation that if someone says something at a state constitutional convention and it seems like that's the intention of the delegate, it doesn't mean that that's what the meaning is, right? It's that what's the original public meaning of the public at that time is what controls, but it's nevertheless helpful. And in all the examples that I give in the book, it seems like these people assume that this is protecting individual rights. They don't talk about the right to govern yourself much. There's a couple counterexamples. Usually what they're talking about is just rights beyond the ones in the Bill of Rights. And like I gave in my examples earlier, there's a balance in writing a constitution between all the rights you want protected and others that we don't want to have to list them all. And so this kind of et cetera idea of this language is what I think is what's going on.
Thanks, Anthony. That's great. One follow-up question, and then I'll turn it back to Professor Lash. So let me just be a little bit more skeptical. So if you're right about these baby ninths, right? And I guess maybe this is an unfair question because I guess my objection could be said about the ninth and your view of the Ninth and 10th Amendments is the Ninth Amendment as well. But if you're right, where are all these arguments? I mean, is your argument subject, in other words, to the dog that didn't bark question, argument that like if this has really been the proper reading of the ninth, these baby ninths for 100 or more years for the states that have had them that long, why aren't we seeing a lot more state constitutional litigants invoke these, unenumerated rights arguments? I know you talk about some of the case law in your book, but I think you even admit that there's not a ton of it. And you'd think litigants would be very creative if your argument was correct. So is it just judicial reluctance to recognize to engage, or what do you think explains that?
And sorry to clarify, the question's for me, Jonathan?
Yes, yes.
Yeah. Sorry. Yeah, so what I say in the book is that this evidence is pretty good when it comes to state constitutional conventions, and then it gets into the courts, and some courts interpret these provisions to protect unenumerated rights in a robust way, but a lot don't. The answer I give is actually the evidence is pretty good that when judges interpret these, and often unenumerated rights are interpreted in a different context, in, say, what we call substantive due process, or maybe some other provisions of state constitutions, and the baby Ninth Amendment doesn't come up. But when it does come up, courts generally find them to protect unenumerated rights. What ends up happening, though, and which drives constitutional litigators such as myself insane when we're doing this in court, is that they will say, so this does protect an unenumerated right. So your right to earn an honest living, your right to garden, whatever. But the government can get away with it if it has, a reasonable motive, or if it passes what we now today will call rational basis, which for those who don't know, maybe some law students, essentially means as long as there's some possible reason you could speculate about that might mean that this law could promote a public interest, then it's okay. And 99% of the time, more than that, the government will win in those cases. So the courts will recognize them to protect unenumerated rights, individual rights. And I think that's because they don't go the collectivist route that I said, other than just a handful of times. But then generally they will say, well, it actually doesn't protect it very much. Now that, more than anything, I would say goes against what they actually say, which is to deny or disparage others retained by the people. Those same courts are not going to give that low standard of review to enumerated rights. And I can't think of anything that would be more contradictory to the actual text than to say, yes, you're right, it protects an individual right, but not very much, not like I would if you invoked this enumerated right that's 7 articles above it in the Constitution. And so there are other examples where courts really do protect individual unenumerated rights with a more robust, at least some kind of teeth in constitutional litigation. And I've been talking about those on our blog the last few weeks with a few examples of how this can actually work in practice, some of which goes beyond in the book if you guys are interested. But generally, no, they've done what a lot of judges have done in other contexts, and that is to not give a lot of it, to recognize the right, but to not give it the due that it deserves.
Thanks, Anthony. All right, Professor Lash, land your final blows.
All right, here we go. Thank you again for this engagement, this civil engagement, which is nice just in and of itself. My first blow, I suppose, punch, would be that, Anthony, I think you're trying to create a possibility of a disjunction between a possible meaning of the federal 9th and 10th Amendments. You're saying, you may not agree with me, but whether I'm right or wrong, you can break that off and try and find an independent meaning of the state 9th and 10th Amendments. And I don't think that'll work. These are baby 9th and baby 10th Amendments. The states that adopted these amendments, the language that they used is just too close to the federal Constitution. That's why you call them baby 9th and baby 10th Amendments. And that means the drafters of these state constitutions were looking back at the federal Constitution. I don't think it's possible for you to come up with a meaning of the baby 9th and 10th that doesn't involve their framers somehow looking back at their understanding of what the 9th and 10th Amendments represented. And again, I think one of the most important ways that they copied them was using the language of the people. Over and over again, they signaled that these were popular sovereignty amendments that were restraints upon government that refused to allow the government to call itself the people. The whole idea of popular sovereignty is that the government is not the people. They may have certain delegated powers, but those powers are always subject to being recalled, and they're always subject to being defined and limited by the people themselves. Now, you said the Ohio Constitution of 1851 was a little bit of an outlier because it seemed to treat the powers of government as enumerated powers. That's not what it says. Listen again to Ohio's 1851. And this is something I thought of while I was reading your chapter in the book. It states the enumeration of rights shall not be construed to impair or deny others retained by the people, and all powers not herein delegated remain with the people. Does not say enumerated, it says delegated, and that is a completely different thing. One of the ways the people can delegate power through certain limited subjects, as they did in the federal constitution, or they can delegate general power to the state constitutions, as they did in the beginning. But in doing so, they are declaring that you may never consider yourself to be the people themselves. The people retain the foundational Declaration of Independence right to hold sovereign power in their own hands. So how might this be violated? And again, that's another one of your questions. How can high powers delegated by the people to the government be violated by the government, therefore empowered? Well, a perfect example of that would be the Massachusetts legislature in the first generation that thought that it had the power to create a constitution for the state. The people of the state refused to recognize the power of the Massachusetts Assembly to create a state constitution, and they demanded that it first be sent to the people in special assemblies to decide whether or not they wanted to ratify this as the foundational state constitution of Massachusetts. There are other ways as well, and I think one of the most important ways would be for some court to think that they had the authority to carve in exceptions from the general powers of the state legislature because the court thought there was some type of Lockean right that should have been added to the state Declaration of Rights, but hadn't been done so. That would be a state institution, the state court itself, abusing the high powers delegated to it and taking on a sovereign authority that was meant to be reserved by the people of the states themselves.
Thanks, Professor Lash. Well, with that, let's open it to Q&A. Please, submit your questions using the Zoom Q&A feature while we wait for some questions to come in. I just want to exercise my prerogative as referee one final time. A question for Anthony. Could you talk a little bit about, how to operationalize this for judges? We talked about what the substantive content in your view might be, but how do judges implement that, right? Is it for those on the call in the participating who may not be as familiar with like Randy Barnett's scholarship and stuff, how do you operationalize that? Is it a Glucksberg history and tradition type inquiry? We got to go right by right and figure out if it's a retained natural right. Is it a presumption of liberty? Is it something slightly different from that?
Yeah, so first of all, I'm glad you mentioned Glucksberg there, because I don't think there's anything about the Glucksberg test in what these provisions entail. I think what we do is we look to the actual language, and when we have rights retained by the people, that's the key word. Now, of course, I disagree with what Professor Lash thinks the retained is, but if we go down the road that I follow, retained is going to be our Lockean natural rights that we have when we again, in a theoretical way, come out of the state of nature and create a government. So what do we give up? Well, we give up the rights that we need to have a government, like the right of retribution that you have in a state of nature. You're giving that up. You're not retaining that, except, of course, in limited self-defense, things like that. You're giving up a right to keep all of your income or keep all of your property because the government needs to get its funds somehow, and so there's going to be taxation for some of that. And there's others there. Now we can go down that road a certain amount. Some people think, well, you need to give up a certain amount before you can have public order, and then some people are going to think there's more of a role for a state in what is given up when we create a government. But that retained, what does that mean? It means those natural liberties that we have, that there's going to be a large amount of them left. It's, again, it's not a Hobbesian society, it's a Lockean society. So how do we operationalize that? The court is going to look, is this a retained right? And say it's a right of the kinds that I gave an example for earlier. Yes, that's a retained right. Okay, is what the government's doing okay? And I don't exactly say in the book what the exact line is. Is it, is it just on the side of a presumption for the government? Is it strict scrutiny? Is it rational basis with teeth? All these different names that professors and judges have given over the years for different levels of scrutiny. What the scrutiny is where you as a litigant, whether you're being prosecuted by the government or you're a civil rights plaintiff coming in and saying the government needs to stop that, or the government owes me damages for violating my rights, you have a fair shot at demonstrating that the government was out of line there and that your rights were violated. I don't think I need to give too much more detail about exactly where that is, but it has to be a real shot. And now I'm not too worried, again, whether it's strict scrutiny, intermediate scrutiny, and that's because from where I am, have someone who's litigated civil rights cases involving a lot of these rights. Rational base, where you are in the rational basis scheme gives you basically no chance at all. And if you're going to have a real chance, that's a world of difference than what most people have been able to do in court in calling upon these rights. And that's the promise that these provisions provide to people.
Thanks, Anthony. All right, so we have some questions. So I'm not sure, maybe this is for Professor Lash, but maybe it's for both of you. So one question is, does the fact that there are, state high courts, in contrast to SCOTUS, are essentially pure common law courts that, have more latitude to create causes of action and recognize different, legal rules, to innovate a little bit more than we, at least in today's environment, think SCOTUS has the power to innovate? Does that perhaps, I think the implication of the question is, does that make a difference, and perhaps maybe should make state courts be a little bit more willing to interpret their baby ninths in a way that protects unenumerated rights?
Okay, yeah, that's a great question. My first thought would be, it depends upon the state constitution. You could have a state constitution that would empower its high court to create certain state common laws, or in a variety of areas, or even substantive laws, or even empower them to recognize and enforce certain unenumerated individual Lockean rights. I mean, all of that is a possible delegation of authority on the part of the people of the state, who then, would have the authority to take it back. And as I understood, Anthony, in your book, that, and as you just said, there are some state courts that have, at least some judges on state courts and some decisions in state courts have moved in that direction. Have, when they've done it, when they've recognized a potential individual reading of their baby Ninth Amendment, they've done so believing that they're authorized to do that under the state, under the state constitution. Now, I'm not surprised, and I think you also mentioned this in your book, I'm not surprised that those readings are all in the modern period. They're not only post New Deal, they're really into the Griswold period, around the same time that the Supreme Court was giving that kind of reading to the federal Ninth Amendment as well. And I think it might be possible for a state to adopt a baby Ninth Amendment today and actually believe that they, as the state people, were invoking a Griswoldian understanding of unenumerated individual natural rights. But I think that the vast majority of state constitutions that contain these baby rights, if you investigate the history, are actually going to have a far more popular sovereigntist, structuralist understanding of what they were doing when they added that right. So we're going to end up with a mixed bag. We're going to end up with some state high courts appropriately reading their state constitution as giving them this general power, whereas other state high courts should be reading their baby Ninth Amendments according to its original understanding, which I think would be far more like the original federal Ninth and 10th Amendments.
Anthony, do you want to take a stab at that? Do you think, the power of state high courts to, exercise quasi-legislative powers, at least as it's understood in our modern post-Erie world, do you think that makes a difference?
So, well, I have two responses. One to the actual question. I haven't thought deeply about how the common law court identification or powers of state courts versus federal courts would make it different in this case. I actually don't think it probably does, because most of the time, common law, when we're talking about common law legal adjudication, it's not constitutional judicial review. It's more in the realm of private rights. I mean, I think you can analogize between the two. I don't see a lot of connection there, but I'd have to think more about it. But in response to Professor Lash's point, some of these cases where courts have identified a baby Ninth Amendment and said, that protects this individual right, and so it's unconstitutional. Some of them have been in the modern post-Griswold era, but a lot of them were earlier. The first one I identified in the book was from 1839 in Alabama, interpreting the very first baby ninth of them all, the Alabama baby ninth of the time. There were a few after the Civil War during that era where courts wrestled with these issues. And I won't belabor the history right now. You can all find my book when it comes out. And one thing, actually, when it comes out, it will be available for free online as an open access publication. So if you were hesitant to pre-order, you might just want to get it for free when it comes out. But you will find in that free version a story of judges in Iowa wrestling with this concept right after the Civil War. Iowa at that time was a kind of a hotbed of railroad corruption, and the Supreme Court had a couple cases where they were fighting with some corruption in the legislature on issuing stock to railroads. And there are dueling opinions. First, the majority, and then later it flips and goes the other way, that where the majority reads baby Ninth Amendment basically as I've argued it for, and then it flips the other way, and the dissent rises to the majority and says, no, we need to read them collectively. And so you can see this battle is a very old battle. Now, after that, there's not that many examples, but there are some. I think what generally has happened over the course of US history is when courts are talking about unenumerated rights, the same urge to protect rights beyond just those enumerated, because we all know they're also important, that a lot of that has been done under due process clauses. What today we would call substantive due process. Some people think that's an anachronism, and actually it was something kind of different back then. But just talking about these other rights that are protected, for whatever reason, courts have gone down the road of interpreting due process and law of the land clauses. I think they should be looking more at the text of the Constitution and interpreting these both baby Ninth Amendments, but also these provisions that Steve Calabresi calls Lockean natural rights guarantees, that I think also kind of do that job.
I had a quick question. It's something I'm curious. It's really not a rebuttal. I'm curious about how Anthony is applying this, operationalizing it. So I guess I'm kind of expanding on Jonathan's point. Early on, Anthony, you talked about how there are different kinds of things you might want to choose to do, and that aren't necessarily listed in a state constitution. And take your child to school is one of them. Okay, so under your view, and this will just help me understand scrutiny, right? Because right now, generally, if it's an unenumerated right, it gets nothing more than rational basis review, as you're talking about. So it should be something, you're arguing for something more. But I'm not sure what's included in the box of what gets something more. So suppose that in a state, they require you as a parent to send your child to school, and you don't want to. You believe that you have a natural right to control the educational upbringing of your own child. And so you challenge the compulsory state education law. How would your approach deal, and say the individual wanted to raise an Anthony claim and a baby Ninth Amendment claim? How would that work in that particular case? Because I think this would help me get a sense of how you would proceed.
Sure. Well, I think there, Professor Lash, a lot of it might come down to how that exact kind of idea has come up at the U.S. Supreme Court in the Meyer and Pierce cases from the 1920s. So, what is the parent trying to do with their child? Are they just trying to keep them home because they hate education and for maybe they don't like their child and just don't want them to learn? I'm taking an extreme example, but if there's that kind of motivation by the parent, and the government is saying, no, we really need your child to be educated because then it's going to have a better life, then that might be a choice that might be something where the state can override what the parent is trying to do for the child. But if it's much more likely because the parent wants to send their child to a private school of their choice and assume they have the means to be able
I'm gonna keep control of my hypothetical here.
Okay.
Again, yeah, the Pierce and the Meyer had to do with teaching native language, and that was prohibited. And then Pierce had to do with what school you're going to send your child to, a military institute or a Catholic school or a public private school. No, I'm on the homeschooling. I'm on the true homeschooling thing. This is a mother and child, okay, and one child, one parent, and the mother wants to keep the child home, and whatever education, I mean, the mother would have her own language for it, but she will teach the child all the child needs to know, and the state says no, they must attend a school. A certified licensed school with licensed teachers. And she says, no. And so what screwed, and she said, because I have a right. It's not listed in the state constitution. There's no homeschool rule in the state constitution, but I think I have other retained rights. And so would she get scrutiny? Would the government be put to its proofs? And if so, what kind? What would the government have to prove to justify its removal? Remember, they would remove the child from the parent's home for neglect, right? Something along those lines. So how would your scrutiny work out? What would the court be grappling with in that case?
Yeah, well, so that definitely would be a right that the mother could argue that to the court that, no, I have a right to educate my child. I can take the child out of the school. And then she would argue, what you think she would argue. The homeschooling has been shown to have beneficial effects for children. There's all kinds of children who have been homeschooled and grown up and done great things. I am a competent person. I can educate my child. My child is thriving at home. All those kinds of evidence. What exactly the scrutiny would be? I think it would be that the onus is on the government there to show that, no, we can take the child and it's going to be much better off, and we have evidence to show all of that. Should it be strict scrutiny? Again, I'm not too beholden to exactly what the scrutiny is, but she would get a fair shot to make that scrutiny. I think if you look at the language of Baby Nights and amendments themselves, it says it can't deny or disparage. So it has to be the same scrutiny you're giving to the enumerated rights, whatever those enumerated rights are in the state constitution.
Okay. All right. Thank you.
You're welcome.
Great question. One more question from the audience, and then we'll see if we have any more time. We wrap up at 9:30, but hot button question for Anthony, which is are you aware of the I think I'm pronouncing this correctly, the Hodes decision from the Kansas Supreme Court recognizing a locking natural right to have an abortion? And do you think that decision might be justifiable under an originalist understanding of sort of the Baby Nights?
Well, yeah, I am aware of that decision from a couple of years ago in Kansas. I'm not going to give a definitive answer about whether a right to abortion is protected or not, but I'll explain how we would think about it. Definitely, one of the retained rights that we would have under my understanding of baby nights, but also I would say to most of these lock-in guarantees where they say the right to pursue happiness or the right to liberty or to right to possess property is your right to bodily autonomy, whatever that means. So I have a right for the government not to come along and amputate me. That is definitely a right that I retain. I have a right to other things that I do with my body. Is there a line that can be crossed where the government can intervene? Yeah, I think there probably is. And we could get into hypotheticals about, whatever it may be, self-harm. If I'm 8 months pregnant and I'm taking something that is going to, or 9 months pregnant, push it out there, and I'm taking something that is going to harm the child, and I'm just taking it for my own personal gratification. Can there be regulation of that? I think most people would argue, yes, there can be regulation there. So there's going to be a line somewhere where there are the rights of the incipient child that are going to come up against the mother's right to bodily autonomy. But that's how we think about it. That's where we have the line. Is we definitely, there is a right to bodily autonomy. Now, looking at Dobbs, right? This is something that in the dissent in Dobbs, I think gets absolutely right, where they say, of course, there's a right to bodily autonomy. Now, the majority in Dobbs say, we that sounds really expansive, because then we're going to have things like drug abuse and prostitution be rights. I mean, I think those are the examples that Justice Alito gives. But then goes on to use the Glucksberg standard, and you need this deep-rooted history and tradition, which we know through looking at how courts actually operationalize that, you end up never with a right, because your right is never specific enough. So there's a line between the two, and this isn't just abortion. This is anytime you have a broad right that everyone agrees, yeah, that's a right that we should have, bodily autonomy. But how do you operationalize that? Well, you're going to have a point where you get to where the state has an interest. And so that's how to think about it. Instead of carving up rights into little cookie cutter pieces and saying, well, there's not even a right here, so we can't even get into that discussion. I think that just shuts off the whole purpose of having these provisions in a Bill of Rights, which is protecting those rights. Not protecting those rights, but seeing, yet sometimes the state really does have a role to get in, and that is going to depend on the motivation of what the state is trying to do and the actual facts.
A very diplomatic answer. I like it. Professor Lash, do you have anything to add on that, or if not, that's fine too.
Oh, well, it's excruciatingly different, right? Do babies have baby Ninth Amendment rights? Do unborn bodies have bodily autonomy rights? Is the right we're talking about the right of the individual to assert their self-definition, or is the right we're talking about the collective right of the people of the state to make these decisions for themselves? I guess I'd place myself in the latter category.
Great. Well, I think we can wrap it up there. I think this is great, been an amazing debate. Thanks to both the panelists, both Anthony and Professor Lash. Thanks to FedSoc and the Charleston School of Law chapter for organizing this great event. And I have many more questions, and I encourage everyone to engage with Anthony's book, and it's really a wonderful piece of scholarship. And with that, I will turn it back over to Alexandra to wrap us up.
Well, what a night. Well, I would like to thank our fighters, Professor Kurt Lash and Anthony Sanders, as well as our wonderful referee, Jonathan Urick, for their wonderful insights. And thank you all for attending, and we hope that you have a wonderful night.
And thank you all. This has been great.
Same here. Thanks, everyone.